Well, good evening, everyone. My name is Jose Antonio Rivas, and I'm sorry to be repeating the same name, but every session is a new one, and there may be people connected online who haven't heard it yet. So I am a partner at Strategy LLP, which is an investor state arbitration boutique, as well as an international commercial arbitration boutique, and we also do public international law. I also teach at Georgetown Law, investment treaty arbitration and public international law. I'm one of the co-founders of Washington Arbitration Week, together with Ian Laird, and we have received an enormous support from sponsors, including Deckard and many of you here. So we're very thankful. Also, our hosts today, and we're particularly proud of having also an incredible set of board members, advisors who have in great part advised us on the topics that you see. Today we have tonight, this evening, we're having a panel which is co-sponsored by the ICC, and in fact the moderator is Yogurt Manual Pineda, and before introducing him, I would like to emphasize that Washington Arbitration Week, in addition to the complex topics on various sectors, has also a very practical approach to international arbitration. That practical approach is how to do things in simple terms. Hence, the name of this panel is 5 things that you need to know before you begin an arbitration, and that is basically to share knowledge, practical knowledge, with young practitioners, and by young I don't mean young in terms of age, because there's people who actually move from the corporate world into international arbitration in their I won't say a decade, but you know what I mean, right? So being practical is very, very important to us. Diogo and I, in a way, we have some history, because when we started Strategy LLP, he had already started his boutique law firm, and one of the first panels that we put together is how to be a boutique law firm in international arbitration. So I won't tell you the war or not war stories on that. What I'll say is, if you are interested in that panel, it's recorded, and Washington Arbitration Week, as well as our sister event, which is the World Arbitration Update, basically records everything. Yes, everyone agrees to being recorded. There are consent forms, etc. And why do we do this? We do this because we're creating a video library so that people can watch the knowledge that has been shared for the past 4 to 3 years. And it's actually quite neat, because you can actually look into the video, and it's synchronized with an automatic transcript. And you put 5 things that you need to know before beginning an arbitration, and you should be able to see where those sentences or where those words were said during the proceedings, like a PDF document. And the tool is already in our website, and of course we're running beta tests at this stage, but it will be available to everyone. The videos are available, not the ones that we haven't recorded, but those will too. So with that, let me tell you a little bit about Diogo. He is an international lawyer specializing in international arbitration, public international law, and investigations relating to corruption, money laundering, sanctions, and terrorist finance. Mr. Pereira is based in DC and is admitted to practice in the District of Columbia and Florida. And there's very few lawyers admitted in Florida, by the way. And no offense to those in Florida, but it's one of the most protectionist bars that there are in the country. So that's hard. In any event, his practice focuses on all aspects of international disputes and investigations, with significant experience in Latin America, Europe, the US, and the Middle East. Before founding the Almeida Pereira, Mr. Pereira worked with leading international law firms in Paris, London, and Washington, DC. And he specifically said, be quick. So I will stop there.
Okay. Thank you so much, Jose Antonio. It's a real pleasure. And I also just want to take a quick moment to thank you for all the great work that you've done. Washington Arbitration Week, some of you may or may not know, started only about 4 years ago, and it filled, like, I think, a real need in the community. This is something that, Washington is a great center for arbitration, and it's about time that we have something like this. So I think it's a really great, and on behalf of the ICC, as Jose Antonio mentioned, I'm the ICC YAF representative for Washington. It's a partnership that's very much valued by the ICC, and these sorts of events that build a community of practitioners that engage people as professionals in this area, I think are meaningful, and it's important part of I think my identity as a lawyer, and I think it should be part of all of ours to help build this community as practitioners. ICC YAF in particular is focused on young practitioners and providing a voice and a platform for younger practitioners to learn about arbitration and to become part of the community. Historically, arbitration has had this reputation of having the dinosaurs of the field. And I think maybe, 50 to 80 years ago, some of the most prominent arbitrators were in fact diplomats and senior statesmen type figures. A lot has changed since that time, and ICF hopes to contribute to build a more inclusive practice. So what we've been doing with ICCF the past couple of years is trying to set a series of events that deal with topics that could be of interest for young practitioners, but are also interesting for more experienced practitioners. The idea that I'm trying to go for is sort of like high-level basics. It's something that you can learn very quickly, but maybe takes a lifetime to master, and thereby coming up with subject matter that's hopefully engaging for many people at different parts and different points in their professional journeys. So I'm particularly grateful today to have this esteemed panel to talk with us. I'll start with Ankita. Ankita is a counsel at Gibson, Dunn & Crutcher in international arbitration and transnational litigation and judgment and award enforcement practice groups. She was born in India, but grew up in Kuwait, moved there when she was 3 years old, and shuttled herself all over the world before settling down in the United States to practice law. She cannot, however, give up her globetrotting completely, which is probably why she's doing international arbitration. When she's not on Zoom calls and drafting several 100-page briefs, Ankita likes to take naps. This is, of course, only when her small children allow her to do so. Next, we have Tatiana. Tatiana was originally a pro bono kid, as she describes herself in law school, wanting to focus on human rights and pro bono type practices. This changed only slightly, I hope, when she had the opportunity to serve as legal advisor to Judge Rosemary Barquette at the Iran-U.S. Claims Tribunal. She became fascinated with complex legal, factual, and geopolitical issues involved in state-to-state cases, and that led her to international arbitration. She still strives to maintain her pro bono practice and hasn't looked back since. When she's not working, running, or doing yoga, she likes to hang out with her family and read fiction. Next, we have Mike. Mike is originally from Indiana. He became interested in international arbitration after taking a summer course in law school on arbitration. He's passionate about working with colleagues from different cultural and legal backgrounds, and likes to come up with creative solutions for multi-jurisdictional problems for his clients. You can find him gravel cycling, baking pizza, or playing frisbee with his dog when he's not solving these cross-border disputes. Finally, we have Juan Pedro Pomes, who's a dear friend of mine, former office mate of mine, actually, from Argentina. He practiced in Argentina until 2011 and has been a member of the international arbitration practice at Freshfields in Washington, D.C. since then, or since, I guess, 2012. His practice focuses on investor state and in international commercial arbitrations with a focus on Latin America. He has represented clients and acted as tribunal secretary in numerous disputes involving different industries, including oil and gas, electricity, mining, infrastructure, pharma, and retail. And one interesting fact about Juan, which he hasn't shared, is Juan and I actually used to play on a soccer team. He likes to play soccer and rugby as well. The team was called La Resaca, which means the hangover. I met every Saturday, and we actually have El Coque, Juan Ignacio Garcia Cueto was on a previous panel. He was also a part of this famed team, and I think maybe it's fair to say maybe the best player of the three of us in some ways too. So
and the team started winning when I left.
yeah, could be. So today's topic, as we mentioned, is 5 things to think about when starting your arbitration. And I think there's many things you can think about. I feel like the cliche answer that a lot of people will give you to this question is you have to start with enforcement. You have to start with the money. And I think that's a very critical topic, but I hope that, and something we're going to talk about, but I hope that over the course of the presentation, we can also show you 4 things that might be even more important to think about for your clients. So just to kick it off and to start off from the end, we'll start with the question of enforcement. And Mike, if you can just kick us off and tell us about, why you need to start thinking about this on day one.
Sure. Maybe a lot of people are thinking the same thing. Okay. Can you hear me? Maybe a lot of people are thinking this, but it seems a little counterintuitive actually to start from the end when you're at the beginning, like a Quentin Tarantino movie. But so if we assume we're talking about a claimant, although this is also potentially relevant for respondents as well, let's assume our ultimate goal is money damages. Our ultimate goal, I think we'll touch on this later, could be a lot of things. But if we assume it's money damages, just getting an award doesn't mean that the money is in our client's pocket. You might think of it like, I'm not sure if this is an entirely apt analogy, but I'm going to try it. If you think of the arbitration process, like ordering a package online, you order the package, you click on the box, and then your package gets on a plane or a big truck to a distribution center, and there's a different truck that then brings it the last mile to your house. When you get the award, it's almost like your package has reached the distribution center, but now you have to figure out how is it going to reach your house? How is that money going to reach your client pocket? So, a handful of questions to ask, like, how is that going to happen? You might ask, is the respondent going to voluntarily pay? Does the respondent have a history of complying with arbitration awards? You could look that up for a sovereign respondent. You might have an experience with a frequent counterparty that will tell you a little bit about whether they're likely to pay an award. You might ask, is there a line of other creditors waiting to seize assets of the same respondent? We've seen that in Venezuela and Citgo. That can add an entire new degree of complexity to the process. You might also ask if there are other impediments to enforcement. If your respondent is an EU state and it's an intra-EU arbitration, now we might be dealing with Acmea-Comstroy problems. So that's another impediment to enforcement.
And Mike, maybe you could tell us a little bit more about some of those issues in terms of Acmea.
Sure. So the Acmea, in case you're not familiar, Acmea and Comstroy are a couple of judgments from the Court of Justice of the European Union, which purport to prohibit the arbitration of intra-EU disputes pursuant to treaties between investors and states. Sorry, I'm not close enough to the microphone again. So many award holders of intra-EU arbitration awards against sovereign states might think twice before trying to enforce them in the EU against an EU state, because that's likely to be very difficult, if not impossible, which might lead them to look elsewhere for assets. The United States, for instance, I think we're familiar with some enforcement actions against Spain in particular here in the United States, the United Kingdom, Australia, but these are jurisdictions where you have to consider, are there likely to be assets in those jurisdictions, and assets that are maybe not subject to sovereign immunity defenses? Are they assets that are used for commercial purposes that could be exempt from sovereign immunity? So these are difficult questions, and I think the the overarching point, stepping back a little bit, is why do we have to think about these questions before we start an arbitration? In part, it's to tailor our expectations and our clients' expectations with regard to the time it's likely to take to achieve their end goal, with regard to the cost that it's likely to take to achieve that goal. And it could inform strategic decisions like their openness to negotiating, their openness to a settlement offer, and what the threshold of an attractive settlement offer might be.
And I mean, it's, the way you're describing it, it sounds almost like a client might be like an eager kid trying to get like to a slice of pizza or some candy. You need to like slow them down and wait up, you know? And do you find that's a conversation that you sort of need to have right away with the client? I mean, is that something that that comes up quite frequently, or do you sense that in your practice clients have an awareness of this? Is this something that comes up?
I think they tend to be aware to some degree, and I also think it's a conversation that probably takes place after doing diligence about the underlying claims, to see if there's a there, but still at the early stages before commencing an arbitration. I will say, I think that it's a conversation that can be had even further before a claim arises. This is a conversation you might have when drafting a dispute resolution clause in an agreement.
I think this is an excellent subject and idea, and I think that it's, you know, we have many people in the audience who may be counsel or aspire to be counsel. We also have people who are arbitrators or aspire to be arbitrators. Do you think this is something that, from the arbitrator's perspective, they also have to think about and consider?
You know, arbitrators, maybe to a lesser extent, although maybe that's a controversial statement. I would think that a tribunal should always have in mind rendering an enforceable award. Whether a tribunal would have in mind the enforcement of that award in any jurisdiction across the globe without necessarily a focus on the rules of the seat, I'm not sure about. I'd be interested to know if others have views. I mean, certainly you would think that the tribunal has to keep in mind all of the, you know, making sure that they're rendering an enforceable award under the law of the seat.
No, I mean, absolutely. I think it's something that most arbitrators will tell you that that is sort of an overarching idea is making sure that the product, the award that they're providing to the parties is enforceable. And this is something, I mean, that I think we spoke a little bit beforehand, is something that even institutions worry about. So, I mean, it's an event co-sponsored by the ICC. I think it's worth mentioning that ICC itself conducts a review process of all awards. It has a checklist that it goes through with a panel of experts from different jurisdictions to look at, to make sure there's no procedural irregularities or formulaic irregularities, and you'd be surprised to even catch math mistakes and things like that before they let the awards go out the door. So it's something that is considered. Does the rest of the panel have any thoughts on this question of enforcement from either the perspective of a counsel, arbitrator, institution?
Well, I do think it's interesting because you brought up the potential Acmea Constoy problem, and we are still seeing a number of tribunals issue awards under intra-EU BITs and multilateral treaties, and it hasn't seemed to stop them. So I think when you're thinking about, well, what will make an award enforceable, there are different categories, or there are different buckets, and I think you brought up jurisdiction. Like, well, might not be enforceable in the European courts, but you can probably get it enforced in the UK and the US if you have assets there.
Just another point to add to that, you know, taking this sort of, you had focused your answer a lot on compensation and having the award be something that is compensatory. I have actually, in my experience, had a lot of questions from tribunals, particularly in investor state arbitrations that are seated, not exit arbitrations, but are seated in certain jurisdictions. And something that often comes, something that they're often curious about is the enforceability of non-pecuniary damage award type awards. So if you're asking for interim relief, or if you're asking for some sort of injunctive relief, that is, I think, something that has often come up, and is something the tribunals might be curious about because it's not always obvious whether that kind of relief is available at the seat.
And then, go ahead, Juan.
The only thing I would add is now that, litigation funding, arbitration funding has become so prevalent in many ways, and, people are more used to using it. I think enforcement from the point of view of collection is absolutely clear from day one if you're thinking about, funding. So there's the first thing that you have to think about is going to be that. So I think in that sense, it's really important if you are really considering that, of course, collection is going to be question number one.
Yeah, no, I just am sort of smirking because this is also, of course, presuming that you're on the claimant side. So the darker side of all this is if you have a judgment-proof client who's on the respondent side.
We're talking about launching the arbitration, no? I mean, we're all claimants today.
Well, yeah, I guess so. But yeah, the dealing with a respondent with a losing case that has no assets is also is something that comes up, or if they have assets in offshore jurisdictions, or there's these days, for better or worse, there's a lot of complexity in the asset recovery process, which is inevitably used in arbitrations. So moving beyond enforcement, I promised 4 things more important than that. So I wanted to move on to the next topic, which is really about success. Okay, so I mean, you can't enforce an award if you don't have an award, or maybe you have, you're not going to want to enforce an award unless it's a good award for you. So I thought it would be important to talk about just some of the considerations you want to think about in terms of the prospect of success, and not only about the actual prospect of it, but how to manage that with your client. So Ankita, I was wondering if you had any thoughts on at one point you think about this, how you think about this, how you communicate about these sorts of subjects as well.
Sure. Well, first of all, thank you for having me here. Thank you everyone for attending, spending your Wednesday evening with us. Sorry, that should not have been a question in my head. But I think, it was interesting to me that Diogo started off the panel by saying, well, enforcement is often kind of the first question on a lot of clients' minds as they're thinking about whether or not to initiate an arbitration. And I think that is increasingly becoming true for potential claimants in investor state arbitration, certainly, because you are quite concerned. I mean, you're going to go through this 2-3 year process against the state. You don't know if they have enough assets to satisfy your judgment. I mean, these awards, or the claims at least, are sometimes in the billions of dollars. You don't even know if the state has that much money in their coffers, let alone whether they'd be willing to pay you and how hard they'd fight. But when it comes to commercial arbitration, I do think that what tends to be on those clients' mind is more the prospects of success. Because oftentimes you're in either an ongoing commercial relationship with your counterparty that you're going to be arbitrating against, or you potentially want to engage with that counterparty again. And so if you are going to be initiating this arbitration, a commercial arbitration, the prospects of success both in the arbitration, but also, and I think we're going to hear about this a little bit later, with respect to your overall objective, your overall commercial objective becomes very important. To me, at least, that's, or in my experience, I will say that most of the clients who come with a potential commercial arbitration in mind are very worried about the prospects of success here, success defined more broadly, not just success with respect to the arbitration, but success with respect to the commercial objective that they have. And I think that tends to be, at the center, at the forefront of their mind, because generally speaking, enforcement against another kind of commercial entity is not really a worry for most of these kinds of cases. Happy to stop there and ask, but also happy to go on.
Yeah, no, I think it's interesting. I mean, one thing that I'm sort of curious about is how you look at the potential for success. I find in my practice, sometimes I have, not sometimes, almost always have clients who maybe see things through rose-colored glasses, or have an idea of the facts and what's can be proven, or they sort of come with their own conclusions sometimes, and there's this sort of process of analyzing that as opposed to just taking it and running it, just to sort of a critical intake process there. And I was wondering how you look at the questions of the facts presented to you by your clients, how you look at the legal arguments that your clients are very excited or confident about, how you assess that, and how you deal with clients at that early stage.
Yeah, no, that's a great question. Because, I think we were speaking about this in preparation for this talk, but the people that bring you the arbitration are in the client, whether it's, a certain organizational unit within the client, or whether it's just the individuals who are bringing the arbitration, and who have, maybe they don't have an in-house legal department, and it's just a bunch of individuals, but the people who are generally bringing the case to you have very, very rarely actually lived the case that's giving rise to the arbitration. And so what you often find is that not only are the facts and the case that's being presented to you as a potential case, not only are there holes in the story that's being told to you, because you don't have the complete information, you're getting it second hand at best, maybe third hand, maybe fourth hand, but their perspective is also colored by the role that they occupy in that organizational unit, right? So you might imagine that someone like an in-house counsel might be more risk averse, and maybe they don't want to, necessarily proceed with the arbitration. Whereas maybe somebody who is, involved in the day-to-day of this dispute and it just hates their counterparty, really wants to go ahead and litigate the, I'm trying to not think of a swear word here, but really wants to litigate this arbitration. And they might have a much more aggressive, a much more optimistic view of the arbitration, right? You have to sort of take those considerations into account when you're getting the story, when you're getting this case, and figure out, well, okay, who is it who's actually lived through the facts of this arbitration? Let me go talk to them. That doesn't always happen, right? They might not be available. Sometimes it's the CEO of the organization. They're not going to give you, an hour out of their day to just talk to you about the dispute. They might not be around. I've been involved in disputes where some of the key events, I'm actually involved in a dispute right now where some of the key events took place before I was born, and I'm old. So, and a lot of people involved in that dispute are either dead or have advanced stages of dementia. And, I remember talking to some of these individuals and just, it was a process trying to understand what actually happened 40 years ago. So, it's a challenge to take that incomplete puzzle piece and then add back the missing pieces through these conversations, and then also assess. I mean, obviously, we're lawyers, and so one thing we do, and one of the reasons people come to us is to do kind of that objective legal analysis once you have the facts. And be able to provide an answer to the client that is objective and that, takes away or removes the filters through which the case might have originally been presented to you.
No, I think that's a critical part of the work that we do. And as I'm listening to you, I mean, this case, for example, with events that happened before you were born and witnesses that might have dementia. I mean, there's one question, which is getting to the truth. And then there's another question of proving the truth to the tribunal. And I find that also to be when you have situations where a client tells you something that they believe with every cell in their body, and you hear it and you believe it too. But the question is, how are we going to get the tribunal to believe this? It might be outlandish, or maybe your evidence is just not admissible. So there's it's a long road. It's a long road to get to the award, and of course even further down the line to enforcement. Mike,
I was just going to add one thing. In addition to evaluating the credibility and availability of the witnesses and the evidence, one thing to think about is the willingness of your witnesses to testify, even if they are generally available, even if they seem credible. are they willing to testify? And we had a case recently where one of the other side's witnesses submitted a witness statement, signed at the beginning of the arbitration. The hearing came along, we exchanged witness lists. He was on the list. Eve of the hearing, we hear from opposing counsel that he's not going to be at the hearing. We say, well, that's strange. Why was that? And the tribunal wrote to the other side asking for an explanation. As it turned out, he was originally reluctant to submit a witness statement and testify, but the other side didn't disclose that fact to the tribunal, and the tribunal was very upset about that. It happened to be a Swiss-seated arbitration, so the tribunal resorted to judicial assistance under the Swiss PILA. We convened a whole new hearing. We brought the witness to the hearing, and he refused to answer any questions. So the tribunal totally ignored his testimony, rejected that. It was in support of a jurisdictional objection, rejected that jurisdictional objection, and it was good result for us. But if the counterparty had done maybe some more diligence about that party's that witness's willingness to testify, it could have been, they could have avoided that situation.
That's yeah, I mean, it's a very helpful and interesting case. Juan, do you have any thoughts on these sorts of questions about prospect of success and how that has played out?
Yeah, I mean, I think I personally tend not to believe what clients tell me. It's a good rule of thumb, just, trust but verify, I guess. So yeah, just get documents, whatever they tell you. Don't buy it. I think there's an issue sometimes very early at the beginning of the case where that's difficult because there's a cost to going through piles of documents. So sometimes you end up, I can give you an opinion based on, this set of facts. If these are correct, then this is my opinion, but you're not, saying these are the facts. And that's really hard at the beginning because of costs. Sometimes, I was going to get to that maybe later, but we can mention it. I just mentioned funding, litigation funding, and if maybe a client is willing to invest a bit of money in having lawyers look at the documents, and then you have, an opinion with footnotes, document, and then the funder can go look at the documents and say, oh yeah, there's something really here. I mean, that's gonna, but and at the same time, it's gonna be much better for the client to make a decision and say, yes, pull the trigger, let's have an arbitration, let's invest whatever this is gonna cost, because you know where you're standing. But again, it's tricky at the beginning.
No, and I think as you say, I mean, that has to be a preliminary consideration because, I mean, before you're getting to enforcement, you have to think about, am I going to file this? Are we going to win this? Is this worthwhile to invest the time, money? I mean, it's not only the costs that the money paid to lawyers and to the tribunal and traveling and everything else, but it's also the time. I mean, clients have to devote an incredible amount of their people's time. Some people, end up distracted from their main jobs because they're helping be witnesses in proceedings. So that brings us to a sort of another consideration that we want to talk about, which is this idea of I mean, should you bring the arbitration? When do you start thinking about the potential for settlement? And Ankita and Mike, I don't know if you had any thoughts on this, the idea of settlement and when you sort of, at one point you should think about that, how you should go about considering that or why?
Sure. Well, I would say early and often. I guess I just have sort of an anecdote about settlement. We represented a pharmaceutical company in a potential dispute with a supplier. It was a long-term supply contract. We thought it was inevitable that the dispute would go to arbitration, but because the parties' positions were very far apart. We started negotiating nonetheless. We put together sort of a sensitivity analysis of the possible settlement scenarios. And as part of that analysis, we sort of we put together a model that let us play with different likelihoods of success for the parties on the merits, on objections, on quantum, that would allow us to play with how much the legal fees and costs would be for each parties. What's the likelihood that the tribunal will award costs and fees to the losing party? And that allowed us to figure out sort of where is the breaking point at which it becomes more advantageous to say, let's go to arbitration because we're never gonna, that figure, that settlement figure is going to be too much for us. Or on the other side of that figure, that's a settlement that we can live with because the risk-weighted likelihood of a damages award in an eventual arbitration would be greater than that settlement figure. Ultimately, it allowed us to come up with a figure that worked, and we reached a settlement that was, I think, beneficial for both parties.
I completely agree with that. And I think you would find that a lot of cases, the clients don't necessarily intend to see the end of the arbitration come about ever. The arbitration might be initiated very strategically for the very purpose of bringing about a settlement, right? I mean, we see that all the time. Because it is relatively inexpensive to, file a notice of arbitration that's 10 pages or, meets the kind of bare minimum standards that you need it to, but it can be expensive to respond. It can be expensive for the ongoing operations, and, frankly, just incentivize the parties to go ahead and settle. And for that reason, I mean, you'll also see this happen, to the extent the budget permits this to happen, having completely separate teams in place for settlement and for the arbitration, and they don't talk to each other because you want to maintain that sort of barrier between the good cop and bad cop. And you want the arbitration to go ahead as aggressively as possible, while at the same time extending that olive branch to your counterparty and, having them come to you once they've had enough of your
Tatiana, do you have any
aggression.
thoughts on this?
Yeah, it's really interesting. And picking up on one of the things Mike said at the very beginning, which is early and often. And it's that often point, I think, in the US courts, I'm less familiar with other domestic courts, but in the US courts, at least, there are ample opportunities throughout the course of a litigation for settlement. And there are tools in the court's toolbox to kind of force the parties to a negotiating or a mediation table, at least to have a conversation. And one of the things that I've noticed about that is that it eliminates this perception of showing weakness to the other side by posing the potential for settlement. And in arbitration, frequently you don't have those moments, and you don't have a panel or a tribunal who can or will say, have you guys considered settlement? Maybe we should have some settlement talks or a mediation talk. And so one thing to think about as you're initiating an arbitration is, hey, one of the advantages of arbitration, right, is the flexibility inherent in being able to put together your own procedural rules. So can you build in inflection points where you're going to, at the outset, say to the other side, we'll talk again after the Redfern schedules and the production of documents, or we'll talk again after the initial exchange of memorials, so that you're kind of eliminating that sense of, I'm showing weakness. I like, now it looks like I don't believe in my case, and they're not going to take me seriously if we try and settle.
I think that's an excellent point. And it actually just reminded me, there was recently a publication by the ICC about the role of arbitrators in helping clients settle. It came out, I think, in the last month or so. And one of the tools it mentioned, and I don't know if any of you all have experience with this, is like, it's called a Kaplan intro. So it's at the introduction of the hearings to begin with this a little bit more of a probatory approach to the case, and sort of to sort of begin to tease out some of the issues and understanding where and when there might be a potential for settlement. One of the other interesting things that it mentions in the publication is this idea of, in Germany and many German-speaking jurisdictions, you have an ability for judges to give you their impressions on a case early on. So it's to us in the United States, it sounds like they're prejudging it. It's something that's an anathema to many American lawyers, but you do get this sort of hint about where things may be going, which can sometimes encourage settlement. And I was wondering if you all have had any experiences with the arbitrators playing a productive or possibly counterproductive role in this respect.
I think what you're describing, I'm so sorry, do you want to go ahead?
Please go ahead.
I was just going to say, I think what you're describing sounds a lot like mediation here, right? where you have a mediator basically tell the parties where if they arbitrated, they would come at. So I've had experiences in that context, but I mean, the German system sounds very helpful, actually. It would be nice to get a read from the arbitrator as to where things are going sooner rather than later.
Now, we did have a Kaplan opening in one of our cases, but this is years ago now. But as I recall, it seemed less about, you know, the prospect of settlement than simply sort of another opportunity for the parties to present their cases in an initial form. They later morphed a little bit, but as I recall, I don't think that settlement really played into it for either side, but our positions may have been fairly staked out by then.
No, I mean, but the settlements I've had have been right before the final hearing, which was the worst possible timing. You know, everyone was ready to go. All the money was spent. So yeah, examples of no, arbitration is not really helping. But you know, ultimately the parties, you know, decided to settle. Maybe they have followed a scientific approach like the one you suggested. That was really cool, by the way. Yeah, I mean, no, not in my experience, unfortunately.
Yeah, and so just moving on to the second to final consideration, which we think is important. One, I was wondering if you could talk to us. So, I mean, this is sort of on subject, talking about the Kaplan intros, about other procedural considerations or methods that should be considered by a party or again by arbitrator or respondent in before an arbitration goes ahead.
So I'm assuming there's an arbitration agreement and you're going to go to arbitration, but before you do that, you should lay out what other options you have before starting the arbitration, right? That's what we're talking about. So you should really think what options you have before courts, before starting the arbitration, what sort of, you know, procedures you can file in aid of arbitration, and also you should consider options within the ICC rules, for example. By the way, I used to be an ICC YAF when it was called YAF. Now it's YAF. So now we have the ADR component to it. I will refer to that, which is. So I think before you start the arbitration, you should think, you know, you can go to the courts and they can really help you improve your case in many ways. You know, now it's become very common to use Section 1782 here in the US to, you know, obtain documents. For that, you need to have the arbitration going, but that's an example. You can also get an injunction before you start the arbitration. You could think of, you know, things that can help you, you know, improve your chances of success or eventually securing, you know, collection and award. Also, if you get an attachment or some sort of an injunction or something, it's a pressure point. So when you're thinking about settlement, the more pressure points you have, you know, the better chances, or, you know, you have more leverage. So you should also think about that ahead of an arbitration. Within the ICC world, you can get an emergency arbitrator to get an injunction, for example, some kind of, you know, precautionary measure before you actually start the arbitration. And ICC has a mediation set of rules, which, you know, are good. I think they're becoming. I don't have experience with them. I understand they're becoming more and more used. The nice thing of mediation, I don't know how familiar people are with it. I'm from Argentina originally. We have mandatory mediation before litigation, so people are very used to it. You have a neutral that will fulfill different roles. The nice thing, it's super flexible. You can, you know, the process will work however you want it to be. The neutral will operate in whichever way you want it to be, can suggest solutions, or it can be more, you know, simply bring the parties together without actually suggesting it. You can pick whatever you want. The nice thing is you can have this, I think it's quite cheap. I was looking at the costs. I think it's a cheap solution really under the ICC. And you can have this ongoing before the arbitration, in parallel. You know, the mediator, if the parties agree, can also become the arbitrator later on. I mean, I don't think that's advisable, probably not, but it's super flexible. So it's almost as an assisted negotiation. So if, you can give it a try. But the problem with it is, of course, enforcement. You will end up with basically a contract, which is the settlement. But if you're doing it while you have an arbitration ongoing, you could put that agreement into a consent award. And so the consent award will end up being, covered by the New York Convention, which is the beauty of arbitration at the end of the day. So yeah, I think those are things to think about.
It's interesting to hear you mention all of this, because I think that there was at some point, or there still is to some extent, this assumption that mediation or some of these alternate procedures are really only for smaller value disputes. But I think nowadays you're finding with some of the largest disputes, people interested in mediation, and not only that, but even expedited proceedings. Right, just get this over within a year, even for a large dispute, just because of the hassle of a proceeding. So I think to look at those suites of options is something that that needs to be done, and as early and importantly in the process. So probably the most important thing that we've been trying to walk towards is the final consideration before your arbitration, and the most important is really this idea of what does your client want. I mean, what is the ultimate objective here? And Tatiana, I was wondering if you could help us out on how to unpack that a bit.
Sure. Happy to get us started on that one. I'm sure my co-panelists will have lots of thoughts on this as well, because it is a critical consideration. And I think it sounds like it should be a really easy question to answer, and it is not always a really easy question to answer. So Diogo mentioned at the outset that I'm a pro bono kid. I came with a human rights background to arbitration. And so I was used to coming from a world where there's a lot of emotion and passion and subjectivity from my clients, because they are living the cases that we're bringing. I wasn't quite prepared for that to also be the case when you're dealing with companies and sovereign states. But it very frequently is the case that the clients you're dealing with have strong emotions, and they feel very deeply and passionately about the situation that they found themselves in. And they're coming to us as litigators because they're in a crisis point. And so they're coming at a very vulnerable time for their companies, and often for themselves personally as well. And I think it's really critical to keep that in mind when you're having these initial conversations with your client, that this is not necessarily going to be, as Ankita was saying, this is not necessarily going to be an objective conversation that you're going to be having with someone who's thinking purely strategically and, working in three-dimensional chess. So I think one of the things that I try and keep in mind is that we're zealous advocates, but we're also counselors. And as counselors, it's our job to make sure our clients know that we have their back, we are on their side, we have their best interests at heart, and that's really, we're striving to that end with them. And sometimes it involves just initial really long conversations where you're letting out a lot of thoughts and feelings and ideas before you can even start to get to the questions that will help you elucidate, okay, well, what is it that you actually want to do? I'll refer again to Ankita saying, well, do you want to continue a relationship with this counterparty, or is this over? Do you want to just get out of here? Are you looking for settlement pressure, or are you looking to inflict maximum pain because you're just really pissed off about the way that you've been treated? And figuring out those questions, and the initial reaction may be, no, I'm pissed off and I want to inflict maximum pain. And then you get down the road and they're like, but actually, this is like a pretty important relationship. And I've been looking at our bottom line. So can we walk this back? So I think part of it is to maintain really open lines of communication with your client, and to keep coming back to them with questions. And I think one of the trickiest things to do, and sorry, I'm saying this is tricky without giving you guys any advice, but I think one of the trickiest things to do is walk that line between, as again, Ankita, very, very wise, was saying, between providing objective advice to your client that will help them achieve their goals, but also being that counselor and that trusted advisor who they believe firmly is on their side. And it's only if they believe firmly that you're on their side that they're going to tell you like all the dirty laundry that you need to know to give them that objective advice. So it's kind of a constant shifting of what hats you're wearing, and figuring out how you're going to frame the advice that you give in a way that doesn't come across as callous, but comes across as striving for that goal with your client.
That was excellent, Tatiana. Does anyone else on the panel have anything to add in this, or any thoughts about, what are some of the key questions to ask, or how to go up? I mean, Tatiana, what you're mentioning is time of building trust, and it's not easy to do that fast, right? So some things do have a natural life cycle; they do take time. But how do you approach that? How do you approach that side of being a counselor? And I was wondering, I mean, Juan, if you have any thoughts about how you manage the information and the communication.
Yeah, no, I agree. We tend to deal with the general counsel or a lawyer within the company, and they respond to someone that is on the commercial side, and they get pressure because the deal didn't go the way they wanted. So of course there's a lot of pressure going on, right? And they want to solve this problem the best way they can. I think I think clients want to hear the truth, and if the case is not, maybe they don't want to tell you where the bodies are, or maybe the commercial people don't want to tell them that. So if you can, I think it's really important if you can identify what those issues are and help the in-house counsel weed out where the issues are. Sometimes we also deal with, there's I don't know, there's a parent company and there's a local company that handles whatever business, right? And the problem happened down there, right? And they have their interests, and then the parent company has their interests, and then but you're advising the company, and you want them all to trust you, but at some point, you have that internal thing going on where you really need to, find a way to more or less get to the truth, because at the end of the day, you can only tell them if they have a case or not, if you know what the facts are, right? So that's tricky. That requires a bit of, I don't know how to say it, but there's something off. Then you need to find the polite way of finding out what's going on.
No, and I think that sort of goes back to this idea of, I mean, what is the objective of the client, right? So the company can have strategic objectives. The general counsel can have objectives. I mean, and you need to learn how to, or not learn. I mean, maybe you don't need to do this, but there's something about understanding the complexity of the situation and appreciating that fully that can make your advice better. And just yeah. So I don't know, Ankita, if you have any other thoughts about how to get to the core of what's being presented to you.
Yeah, I mean, I completely agree. I think there is like a certain je ne sais quoi in terms of how you would establish trust. A lot of articles have been sort of written about the psychology of trust and, what it takes to get somebody to trust you. And I think the core of it is what I would, for what it's worth, my opinion, is I think that the client needs to be able to understand and believe, I would say, not just understand, but believe that you're on their side and that you're not doing this, you're not asking them to pursue this case because you want to have, a case that's going to bring in money, or you don't want, you're not siding with, for example, one or the other person or entity at the client. You're really just looking out for what is in the best interest of the client. And I think establishing that, making them believe that is really what helps them see that your advice is truly objective and correct.
If I could bring us back to one or two of the things that we talked about earlier, about other types of ADR, other dispute resolution procedures and settlement. If after hearing the client out, evaluating the facts as they tell them to you, maybe the witness testimony, the documents that are available, it becomes evident that, hey, you know what, maybe this is something that we should mediate. Maybe this is something we should try to settle. Making that recommendation, which is, you know, it may result in less fees and you know, less work for the lawyers, but you know, I think that's a part of being a trusted advisor is, you know, advising them about the other options. And at the end of the day, that might make a client very, very happy and give them the result that they, not that they thought they were looking for at the beginning, but the result that is right for them and that they need.
That's excellent. So I see that we're running low on time, and I want to make sure we had a chance to get your all's input on this. So just quickly want to summarize the 5 things, just so we all know them before we go to questions. Was enforcement, potential for success, legal and factual, potential for settlement, procedural considerations, and then the most important is really the client's ultimate objective. Those are the 5 things that we sort of wanted to bring to you today. And with that, I have a couple questions from our online audience, but I first wanted to give priority to those of us who are here in case anyone had any questions for the panel. Please.
How does your approach change? Does the approach change if the client can't pay your fee? And once you receive third-party funding or take the case on a contingent?
I'll go ahead and take it. I think I wouldn't say that the approach.
Yeah.
Oh, sorry. So the question for those listening in is, does your approach change, and if so, how, if you are seeking third-party funding to bring a claim? Okay. So I think that in some ways it changes and in other ways it does not. I think the necessity of always making sure you understand your client's ultimate objective, getting their trust and giving them solid advice as to whether or not this is a meritorious claim worth bringing, if it's worth the time and the costs that are going to be involved for them, even in just securing the litigation funding. That to me doesn't change. What does change is the level of due diligence that is sometimes involved in being able to bring the case. And I think there are some really profound advantages to having to do that sort of intense due diligence that you'll need to do in order to pass muster with a litigation funder to get funding for your case. You're going to go in much better prepared. And you're going to know a lot more about the case and the facts than sometimes you would if you have a client who is just paying for things and you don't have to go through the whole, like, well, let's document everything before I get to this.
I have a quick just thought on this. So I think there are cases that are pro bono cases, right? So those, of course, they're a separate category. I find the trickier cases if you have a client that's not a pro bono case that's telling you they're going to pay and then the payment doesn't show up and they say next month, or actually we have a deal in Angola coming out and as soon as that money comes in then we'll pay you. And what you're talking about there, that's a dynamic of a client that is playing games. And I've found that if you want your clients to respect you, you have to respect yourself. You have to have boundaries. You have to be the authority on how the proceeding is going to be run. So I think if the quickest way to lose your client's respect is if you don't maintain boundaries as well. So I do think that's actually an essential part of serving your client is to have lines and to have them very clear and transparent. And I think that process of knowing when to say no and being firm about that does build respect and it builds trust too. So I think it's sort of a flip side of some of the service that we're talking about.
Would there be any other considerations apart from the 5 that we spoke at length if the payment happens to be a state or the state or sovereign being the payment?
In terms of this question of payment?
No, in terms of it's a different question altogether. The 5 things.
Yeah, the 5 things. I think they're the same. I think they're absolutely the same. I think they become more complex though. I mean,
what else apart from these 5 would you think would be material?
Well, so for example, I think like this question of what's the ultimate objective can shift dramatically, right? Because you have political objectives that can be partisan as opposed to national. There can be administrations that have changed in the meantime. There might be questions that you can't prove, but are of like ultimate existential political importance to a situation. So I think they changed dramatically. I'm wondering, Tatiana, I see you nodding, if you have any specific thoughts on the question of sovereigns and how this changes in that context.
I mean, I think that's right, that the ultimate objective can get much more complex and can change as political administrations change, or can change as you're dealing with different, agencies or entities within the sovereign. I think the question of like what success looks like can also be very different, and that's intimately tied in, of course, to what your client's ultimate objective is. But does success for the state look like winning this particular claim and then losing a whole bunch of investors who are now terrified of coming into the government or coming in and investing? Or does success look like getting a settlement that no one knows about, or can, what I'm saying there is states might have concerns about a private settlement versus public proceedings. So I do think there's just the same five, yes, as Diogo was saying, the same five factors. It's just the analysis of them looks somewhat different.
And just to add on that, I think it's a great question. But the other point is states come in so many shapes and sizes, right? There's some states that are huge monstrosities, and there's others that are kind of like family-owned businesses. So I think it's an important thing to just to bear in mind. It's even clients come in different shapes and sizes, but I think we created this framework as general as possible. So yes.
In your experience, do you notice a difference in enforceability of basically after settlement or mediation versus when there was an actual arbitration report? You see that the compliance is, for instance, higher in settlement.
I don't know if my co-panelists have any concrete experience with this. I have not had specific experience with enforcing a mediated settlement that was not voluntarily complied with. I think that ordinarily in negotiating a settlement or mediating a settlement, you would hope that the parties would be willing to comply with their agreement right away. I suppose it must happen that is not the case. But I think one of the things that Juan brought up earlier is that part of the magic of the arbitration system is that if the mediation takes place in the context of an arbitration, we can reduce that mediated settlement to a consent award, which would potentially assuage some of the concerns that you might have with enforceability.
So I actually have had that experience where, and so I would say that the difference isn't necessarily at the stage of, or the way in which the award has, or the settlement has been brought about, whether it's through settlement, mediation, or arbitration, but more about the type of entity against whom the award has been rendered. And, as I think I kind of mentioned it at the beginning of when I was talking about success and enforcement, it's very rare that if your award is against a commercial entity, that award will not be paid, or if you've settled you've agreed to a settlement against another company, especially if there are either ongoing or potential business opportunities with them. It's rare that settlement won't actually be complied with, or that award won't be complied with. But states are a completely different ballgame. So the example that I have where a settlement was not complied with was a state. And so that's, and for a host of reasons, right? I mean, not all of them necessarily being bad faith on part of the entity that settled or the people that settled with you, but they might simply be out of power. And so you're facing a new administration who's decided it's not in their interest to go ahead and pay the award or comply with the settlement terms as that they had been negotiated.
No, I'm just gonna say we actually had a situation like that, and it was an investment case. We had a preliminary award that had clear instructions from the tribunal what needed to happen. Then there was an agreement between the state and the investor, and then it implied going through the courts, and then the local courts would issue a decision, and it was very clear what the decision had to be, and this was not meddling with the court. It was just what would happen, and then the agreement was reached, and then our client filed before the local courts, and then because of political reasons, the state lawyer in that case decided to do some shenanigans that weren't supposed to happen and weren't part of the agreement. And then that we had to go to the tribunal. The tribunal, anyways, it wasn't pretty, but ultimately we ended up with the same result. It's just that there were a few hiccups because of, it's a state, so multiple interests, and it's difficult to have to manage that.
Well, with that, I'm going to just say thank you very much to the panel, and thank you all for coming here. We have drinks and reception being served outside. So once again, thank you all for coming.
I was asked to tell everyone that if you registered, there are name tags outside on a table.